more than enough. In Melbourne town, where the suits all grind, there's a lawyer with a vision, one of a kind. He's the Aussie Overlaw'd. He'll fight for your rights, and he's got his own channel shining bright. From the courtroom to the web, he's got it all, sharing legal knowledge, answering the call. He breaks it down in a language we all understand. The Aussie Overlaw'd taking a stand. With his Aussie charm and his legal know-how, he's the hero we need, showing us how. He fights for justice, no case too tough. The Aussie Overlaw'd, he's more than enough. He's more than enough.
And good afternoon, good evening, and good night, and welcome to the Friday show. I am speed running as many of the hearings as I can. I got a pair of these, and I'm acutely aware that I'm about 8 hours worth of hearings, including Adrian Kearney's evidentiary hearing, and that there is a full day to go today. So I've done as much cleaning in the house as I can. We're going to get stuck straight into this. I'm hoping to get 4 hours in at 1.25 speed. So wish us luck. All right. All right. Got the audio up. Yes, that's fine. There's a camera that far over that way. It's a bit better. No, that's fine. If you need to tap out, go for it, breweries. I just need to speed run as much of this as I can because I'm acutely aware that I'm running far too far behind. And, well, I mean, you know, work is what as work does, so. I don't have any audio.
You can help me. This is an Overlaw'd Superior Court in Philadelphia. And you can, you shall be heard. Commonwealth of Massachusetts. Was now open.
Hey, Brett.
22117, Commonwealth versus Karen Reed. Can the counsel identify themselves starting with the Commonwealth?
Okay, 1.5 might be a
Morning,
bit
Mr.
too
McLaughlin.
fast.
Morning, Adam Miles, the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan.
Morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the Street.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of...
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Lessie on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses.
What the fuck? Okay, we're already off to a flying start. I knew that she was going to rule to allow the ARCA witnesses, but I didn't think that she'd go so far as to use the words deliberate in terms of the candor. No spoilers, obviously, but damn, okay. She's come out swinging.
They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here,
Thank you, Jill.
the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations.
Ooh. Whoa. Okay. It is only because I already know the outcome of this, because people were kind enough to send me spoilers. If I had come into this without pre-knowledge of this, I would be expecting for her to have removed Jackson. That's insanity. Wow. Okay. Really, and that's really where you're going with that, with all the violations that Brennan's thrown in as well. Okay.
And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here.
Colloquy. So fancy Q&A session. How long does this last for? Oh, not particularly long.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So
right.
I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Mr. Yannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We are in the state of Massachusetts for that all-important evidentiary hearing where Aiden Kearney, who goes by...
Because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word. And I need to be able...
Yeah, okay, fine. Duty to the court and candor to the court is a paramount duty. It's one of the ones that we are taught in ethics class, that we have to make sure our obligations are... Whatever the hell that was. Why does it keep taking the damn... Something keeps happening and it keeps flashing on the screen. I assume that's not actually affecting the video. Yes, it's a paramount duty to the court, but you know what it also is? Due process, fair procedure, and an unbiased trial.
Able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations.
Okay, well, at least the ARCA witnesses
I will allow
are...
a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions.
Wait, what the fuck? Oh, so you're just making it like... You're just holding his hand and basically saying, yeah, put whatever you want in front of me and I will basically rubber stamp it. Right.
So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you.
No, of course the rules don't apply to the Commonwealth. Brennan and Lely can say whatever the hell they want.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Dalbert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following. Based on the findings of his autopsy, his being the deceased, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism.
Yeah, I don't know why it's favoring one over the other.
Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to
Also
treat
helps if I actually
incurable
turn my own
cancer.
audio
That's
off.
what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology
Oh, she takes after me so much. It's not funny, Joe. Honestly.
And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scordi-Bello. Dr. Stonebridge didn't even venture into the manner
Yes, it
of
is,
death
Joe, and I
at
don't
all.
know why
Didn't
it's doing that.
comment on it.
It's actually coming from
Dr.
the audio of Court
Scordi-Bello,
TV.
who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his finding, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe
There,
fell
I've actively
backwards,
moved it more
his
to the right.
injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that?
Oh, sweet mother of God, have I missed
It's
you?
also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a pedologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident, so there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is Fractures of the Classification and Clinical Features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information. But it says, under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his one-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determine the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts, it's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin, and in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts, where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right, thank you.
Fair and reasonable arguments. And here comes Spanky.
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon.
And of those 35 years, how much of that has been determining the cause of death for someone? Granted, he's probably conducted a few surgeries on an individual that has had a fall or had a head injury or something like that. Is he qualified to be determining cause of death, though? I'm going to go with probably not.
See that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached.
Can he outdo?
In his internships as a neurosurgeon, he engages in...
Damn it, Dr. Grandma?
An internship in...
What was I calling him?
Pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries.
And
His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's principal investigator in VAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, in severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters, that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on the journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. Presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon, who has this extraordinary experience, is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately
that might just be one of the stupidest fucking things that have come out of his mouth so far. A pathologist treats someone that's already dead. Holy shit, Brennan, come on. You cannot be that stupid.
familiar, not just with looking at a deceased in a lab. He's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the...
I don't know why the splash screen keeps popping up, but it seems to be every time I interact with the page as well. Is that the thing that Liam Neeson's wife died from when she smacked her head in the ice? I can't remember if she hit forward or backwards, but like I've been, ever since I've heard that story, I've been paranoid about head injuries. I really have. For you to be acting normally and then dead within 24 hours, that's messed up. I just can't remember if that's the same thing or not. But what the fuck is he going on about? Misspelled a word or two. Oh, good. A neurosurgeon is no more qualified to determine cause of death than a carpenter is qualified to determine whether or not I built my shelves correctly. I mean, yeah, they might be tangentially related. Yeah, they've probably got a fair amount of knowledge in the area. Are they the preeminent experts to be asking what caused the death? When, I don't know, there's the medical examiner, the coroner, the individuals that engage in the autopsy? He's just scraping the bottom of the barrel for whoever he could find to support his case, isn't he? Someone that's willing to say what he wants them to say. Holy crap.
Autopsy report show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise. And
he's actually saying that a neurosurgeon has more expertise at diagnosing a cause of death than a medical examiner. I'm going to need my punching bag for this. Where is it? It's in the lounge room.
It's no different than the pathologist that's offered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. Lopesada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with countercoup, having treated tens of thousands of patients, and he understands in countercoup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of countercoup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth, but we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
Great, thank you. Mr. Ellis, anything final?
He wants to call a neurosurgeon instead of the medical examiner. Well, I can honestly say that at this point, I'd be putting I'd make sure that the medical examiner's on the defense witness list. And I'd probably ask them, do you personally have any idea as to why the Commonwealth would prefer a neurosurgeon's opinion over your own? Objection, speculation, doesn't matter. The jury heard it.
Yes, thank you, Ron. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? it takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here.
Shouldn't have said
But
desires.
in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Do you want to respond at all, Mr. Brennan?
I was about to say, do we think that Alessi will even get into a seat before she rules against him, or what?
At some point, arguments become semantical and theoretical, but not practical.
Are you serious?
This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon,
Maybe he's not a great doctor.
engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying. Because
That is not an appropriate manner. It doesn't matter if it's obvious. We don't look, it's very clear, it's very specific. Under procedures of the court, it doesn't matter if it's obvious that something happened. If it can't be proven, if there is no evidence, if there is no facts behind it, if there is no, I don't know, I mean, they said there's 4 peer-reviewed articles? This guy is not qualified to opine on manner of death. Yeah, sure, he might be able to give an opinion as to what the injuries may have occurred, not what would have caused them. Jeez Christ.
because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience,
It's anecdotal.
seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alesi, but that is so unnecessary because it's obvious. Thank you.
Okay.
That's a piss poor argument.
All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
Of course
All right,
there is.
So I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like...
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it?
She
Was there...
did.
Okay.
She did indicate, and that's part of my argument, Your Honor. Which is,
So go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial, no dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall...
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern for chalk as I do an exhibit.
And so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass. There were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
no,
right?
This is more attendant to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex. The court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
do you have the date of her testimony?
Oh, gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So, obviously, I remember her testifying. I remember seeing this previously.
June 5th, 2024. Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear
don't say it'll make it easier for the jury. She's going to knock it back like there's no tomorrow.
And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
Devastating to my case.
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night.
Oh, yeah. This is where I presume he's going to talk about the documentary. Karen, not that you're ever going to see this because I'm not big enough for anyone to ever take notice, but for God's sake, stop giving interviews, okay? Nothing you say at this point to anybody is going to help the case. And with more information like this coming out, I mean, even I had trouble reconciling how the hell you would be picking pieces of glass off his face. And then I heard about the fact that he supposedly took your cocktail glass out of the car. Okay, fine. Maybe there's something there. Maybe there's not. I don't know. But woman, stop talking. Please.
For the first time on a public hearing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful.
It doesn't
but
clarify anything.
I don't
Not
have
a bit.
confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
All right, so Mr. Jackson, what I'm going to do is just hold off. Hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. It's just, I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure,
if Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
And kicking it down the road again.
With them to something they want to explain.
All right, great, thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has
Proctor, or is
maybe
this-
a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand.
The Aruba witnesses? What?
The paper
They find
number on the
people in from
Commonwealth is
Aruba?
585. It's got your 11 on it, though.
God, they really. Hey, oh, look at that. We drink Fiji water. It is nice to know that I share the same tastes with Mr.
So
Alan
the
Jackson.
defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the
Johnny Sin's still sitting
let's
there
just say
staring down the defense.
Aruba witnesses. I don't.
Turtle Boy's up for witness intimidation, but oh
Marietta
no, he's allowed to sit
Sullivan,
there and
Laura
stare daggers at
Sullivan.
her. Yeah, that works.
Does this, Mr. Yannetti, I think this was one filed by you. Maybe it wasn't. Does this include the children as well?
This does not. This is limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the
Oh, right.
Falls,
There was a
there's
time
the
that they were in
defendant's
Aruba, wasn't
statement.
there?
The victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay. There we go. All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 559. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for review, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I know.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reeve to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all in the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view.
Good God, don't put her in the back of a cop car.
34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. So it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why
I was
don't
going to
we
say I disagree
table
with
this for a
that.
bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine, I think. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right, so let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars.
Oh, no shit. That is surprising. I was not
All right,
expecting
so
that.
defendant's motion limited to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested, but additionally excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments.
Hey-o!
Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. He or she was anonymous.
Okay.
I don't think that. Wait, why would it matter if it was a deliberating juror? I mean, even like, okay, they were there for closing statements, and there was what, from memory, 2 that didn't deliberate. What does it matter if they were one of the ones that didn't deliberate? I think it's probably worse if they weren't. A, to me, that was Bev just trying to interrupt Elizabeth while she was trying to make a argument. B, what a stupid fucking question. Because it does not matter whether they were deliberating or not. If the juror felt intimidated during closing or during the trial, they should not be there. They should not be sitting across from the jury.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right, so obviously is not something that should be in a motion, okay? If
Oh,
experts are,
fuck
if you've got
right
any-
off. Excuse me? You literally just listened to Brennan talk about how obviously the neurosurgeon was going to be able to testify because obviously he had decades of experience. Fuck off.
agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I don't want to speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted.
Hello there.
It's not a given, okay?
Hey, Flux.
All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable.
It was a fucking juror! And you already, at this point, you already know that Higgins and Albert are going to be listed as third-party culprits. In the jurors' minds, these individuals are going to be painted by the defense as the ones having committed the crime, and you want them sitting across from the jury during closing arguments prior to deliberate.
It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion.
Oh, fuck
Ms.
off.
Reed has 3 potential family members who are potential witnesses for the government. And certainly, I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. Not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rest and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
So not only is he saying that the McAlberts should be sitting across from the jury, he's saying, oh, we're doing it so that she can have her family there as well. And we're not just saying that they should be there for that. They should be there to be able to witness the entire trial, even prior to giving testimony.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
one might have been yours. I could be wrong again. All right, so Ms. Dianetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial.
I was taken under advisement. She hasn't made a ruling on it yet.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
He's not going to want that.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I would say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that,
which is standard. When you're trying to pick a jury, obviously each party is going to try their best to make sure that they pick jury members that are sympathetic to their cause. Now, using a questionnaire basically means that the wording is agreed upon between the parties. There's no live questions, and Bev gets final say over what the questions are. Whereas if it's conducted live, Jackson, Yannetti, Little can ask whatever questions they want of the jurors at the time to ascertain whether or not it's appropriate or not. He just wants to make sure that he gets as friendly prosecutorial jury as he can.
really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides.
Your Honor, it also allows you to act as gatekeeper as well.
I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary, and I understand that that is been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial.
Oh, fuck off.
I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire.
Do you think she's had a nose job?
But I want you to agree to it, and if you can't, I need that. You know, I need that by the end of today. If you're not going to agree to it, have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
What? By this stage, it's what? How far are we in? An hour and a half. They start at what, 9:10. So by this stage, it's 11:30, heading towards 12 o'clock in the middle of the day. And you're saying you want them to have that to you today?
But we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we've got to go back on to start with.
So let's do that. What Mr. Brennan's new to the case, what I needed a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case. Unfortunately, I think because of all the publicity.
That's a crock of shit.
We'll
That's a
do
crock of shit.
Extensive voir dire at sidebar.
Oh, I'm a
and the
big proponent of it, but I'm not going to do it
So
here because
566 then
I've
is
had some
denied
negative
because it's
publicity in the
requesting
press, and
panel
I'm worried that people are going to say stuff about me.
567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So,
That's a fair and
is there an
reasonable
objection
argument.
to that, Mr. Brennan?
Does not, I believe that rule should apply to both sides. I have no objection.
Okay.
Good.
Mr.
There you
Jackson,
go.
do you agree it applies
That's
to
an
both
easy one.
sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. $570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation.
Oh, this is going to be denied.
All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt.
Oh, I would have laughed so hard if we went. They went on to describe the shock and horror.
From third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it. In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agree, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There's an enormous amount of emotion
Megan, that's coming up.
Injected throughout the community, this community and beyond, and we don't control that.
So I'm trying to do these in order. So I've got the 18th. This one we've got for the 18th. I've got the. I'm going to do the Rule 17 hearing in this. I'm going to slot that in the middle between that and then doing yesterday's 6 hours. So I'll probably get to that after this, and then we might get part of the second day of the conference in.
And if people have suffered as a result of that, Ms. Reed, very specifically, should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her.
Agreed.
And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? A low-cost standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed...
When was that no bill issued?
You said when or where?
When?
I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believe, and I think what the court would have ruled, would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling, that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was, whatever that door was, it was on some very, very significant lubricant. It was going to be open very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to this Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in first trial.
What are the odds that she actually agrees to this? He's asking for guardrails to make sure that he doesn't open the door with what McCabe is got, because you know she's going to get on the stand this time around and do the whole shock and horror, and it was so horrible and just yeah, because that's about all she's got, really. Because, well, you guys all saw the testimony the first time around. This is not unreasonable, but I can see right now that Beb's going to turn around and say that's not my job.
Trial, because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. in any event, I think the court understands what our concern is with regard to this subject matter.
And what the
we
request
don't want
is.
a free-for-all of people, one person after another, walking into court and basically lambasting the defense, for all intents and purposes, about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
How hard's he going to argue against this?
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Miss Reed...
and now he's going to go out of his way to conflate shit as well. Go for it, Brennan. Let's see how much of a smarmy git you can be on this.
Talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information, but to try to make a public record that is so grossly, not only inept, but fraudulent. I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum.
Oh, fuck off. That's exactly what she did.
Case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text.
I need to check something.
To their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
God, he's a piece of shit.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note.
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Ms. Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said. At the lowest
Jennifer
level
McCabe, she was on the prosecution's witness list. Wasn't she called as part of the
Brennan
prosecution's
can stand up all he wants and say, I
case
saw
last
a TV
time?
show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. And so, sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. We could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony, and I'll probably seek the court's guidance. Before I ask a specific question that I think comes anywhere close to that, we'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'll look at this a little more closely.
I'm shocked.
All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and we would respond, including with regard to the motion.
Okay. So, Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233,
I think the only one that's doing it anywhere close to pro bono is Alessi.
Issue with that. However, these records
She's
are
almost $1 million in the hole.
routinely admissible. Commonwealth vs. Hallinan, 491 Mass.
I think,
730,
or maybe even more.
736, Note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable,
I'm hoping to be able to cover it as much as possible.
Admissions, as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy-dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in the serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B.
I gotta pee. Hang on.
In terms of
I'll be back in a second.
changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable. It should be excluded.
Okay. You want to respond, Mr. Brenner?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth, for this trial, has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first
10
trial,
seconds, I'm expecting
ever
a dog
reference
to bark
that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk? All right, so what I'll do is I'll seek counsel at sidebar regarding scheduling.
All rise to the court, please.
You are muted.
We'll be recessed 15 minutes. All rise to the court, please.
You are muted.
So, Mr. Jackson, I'll hear you on that.
All right,
one
I'm
motion.
having
Thank
making
you,
great
Your
time.
Honor. It won't
Fantastic.
take very long. I want to formalize a motion to continue the start of the trial.
Oh, here we go.
Which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago.
She ain't going to delay it. What are you
Given
kidding me?
The complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If, in fact, the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial...
Wait. Bev went to school where Morrissey's father was a teacher? No shit. Oh, and they're looking to get a hold of Morrissey's personal emails and phone records. Huh.
Into upheaval. Once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because that's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached, and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
That's disgusting.
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday. And then the reply
No,
brief
I'm
would
sorry. Can we point out a minor difference there? He was so polite just then. He stopped to check to make sure that he got the guy's name right.
be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or Or do you want to handle this, Mr. Brennan? Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. His attorney.
I get she's a state judge. How the fuck does she not know how any of this works, though? A, she knew that the appeal was going on, so maybe a quick Google search. Shut up, Belle. But more to the point, lawyers have to engage in something called continuing professional development. I myself have to engage in 10 hours per year, which reminds me, next Monday is my cutoff date. I need to get a couple more hours. But surely she had to know this was coming. Anyway, all right.
Attorney Jackson mentioned parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward would be ideal. You know, which charges are going to go forward and which not. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from some additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss in the final pretrial conference is how long this case is expected to take. So I think the Commonwealth filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
And honestly, thank God for that. As bad as it sounds, I'd rather have shorter days that go for longer, because I'll be able to cover it. All right, looks like this sidebar goes for a little while.
Give it time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
All right, to the court, please.
All right. So that was the first of the hearings. I'm going to switch across to Aiden's, Adrian, damn it, Turtle Boy. I'm switching across to his evidentiary hearing. knock that one out because that one's only, what, 44 minutes, and then we'll get started on yesterday's hearing as well.
By Turtle Boy. He's the blogger charged.
What is the session? May be seated.
Good morning, Your Honor. May I call the case? Yes. For the record before the court, numbers 1 and 2 on today's Commonwealth versus Aiden Carney, 23 CR 313, 24 CR 43. Mr. Carney is present along with his attorneys Timothy Bradel and Mark Bedrow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on various motions. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the Commonwealth.
Good morning, Your Honor. Timothy Bradel on behalf of Aiden Carney.
Good morning, Mark Bedrow, Mr. Carney.
Okay. Good morning. First things first, I served with Attorney Cosgrove when he was Judge Cosgrove on this court, and I think this was the only place we overlapped, and we were sitting at the same time. I don't think it raises an issue for me, certain item touches. I understand that fact has been disclosed to the defense counsel. The defense counsel doesn't have an issue, but I want to just flag that and make sure that's correct. That's correct, Your Honor. We're fine. And does the DA's office have any problem with my presenting?
No, Your Honor.
Yes, I think you're correct, but I also wanted to actually... Katie, I'm pretty sure you're right. I also just wanted to actually watch this one, but... You're probably right. I should probably stick to the ones with Karen, so... Shit, hang on. Which means that I need to do this, because now I look like a moron. Hang on. Yeah, this was the one from 3 months ago. Shit. That's that, but that's only a minute later. That's the arraignment and revocation of bail hearing, but that's not what I want either. Which one's that? No, that's Karen Reed. Total the MA versus Karen Reed. Oh, it is a Karen Reed one, is it? Okay, hang on. You know what? I could just double check which one Melanie was watching. Be very helpful. Nope, except that's not the one that I need. Damn it, come on Hayden, you don't have time for this. Okay, that's not that.
For leaving.
That ain't the right trial though, is it? That's not the right hearing.
Rubber ducks around.
No, that's not the right one. Elders this week. That's definitely the right one, but where is the full hearing?
So, folks.
Cameron Reed hearing streamed 2 days ago. But that isn't the right one, though, is it? Because that's... No, that should be literally just the one that I just watched. How is it that everyone seemed to have it, but this... Issues under consideration. Go to the beginning of Karen Reed Day 2. Oh, shit. Is that... It is too. It's part of the Day 2 of the hearing. Okay. Turns out I had it the whole time. Fan-friggin-tastic. Alright. My bad. Why is my computer acting so stupid? It's acting up in ways that I've never seen it before. Need that one open. I can probably close that one. I need that open. Alright, screw it.
Have from the beginning kept a very line of separation between both Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket.
And now I'm going to have to change the audio because now it's favoring the right over the left.
What I know is that there are 2 phones that were searched by Trooper Kelly and is in the possession of the District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that but relationship.
Okay, hang on. It can't be this bad for... Nope, that is not that. How's law and crime looking? That was just terrible. Live. It's 2 weeks ago. That's 13 days ago. That's 2 days ago. Oh, there it is. Oh, looks like the streams aren't terribly great anyway. Or is it literally just
see any case
something's going on
law
with my computer?
that specifically says under these circumstances a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed.
Oh, okay. Hang on. I believe something is going on because for some reason my browser is chewing up 80% of my memory. So I'm just going to have to fix that for a second. YouTube, no, don't restore the previous ones. I'll just set it up myself. Oh, there we go. That's what I need.
Karen.
Okay. And then I just need to come over here and fix up the news page and make sure that it's up and running. I was wondering why everything was so friggin' sluggish too.
Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Carney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I refrained.
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a...
Boom. Yannetti was pissed.
ruling with Mr. Carney, so I'm asking that Mr. Carney is concerned to be at the table.
Even Karen's like, what the fuck do you think you're doing, dude? Now, I'll admit, I've already seen a clip of this, and I was extraordinarily happy.
I'm not sure why we're being joined by Ms. Weedstein, unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the Court. We didn't see which case number was called for this Rule 17, if it was Mr. Carney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar the day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue
is being recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Carney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has a right to counsel, and we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
And respectfully, I don't necessarily disagree that from an evidentiary standpoint or a disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
Counsel,
Brennan knows he tried to sneak something sneaky here, and he did, and he's not getting away with it. He's not happy.
This motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
We did to Justice Cannoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Mrs. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be able to mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes a ultimate ruling, and once Mr. Grable is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
No objections.
Screw the Doritos. I need popcorn for this.
That's an issue in terms of a filing.
Thank you. Thank you.
Well, Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her considerations there too.
Appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because of Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress searching of a computer or telecommunications devices.
To be perfectly honest, I thought she'd already denied it, but I wouldn't. I mean, she claimed that there was a conflict of interest. My argument for that is that whilst their interests are aligned, and there is, unless there was some reason that they were going to be pitted against each other, the conflict doesn't really exist. And provided that there's an open waiver between the two parties, there shouldn't be any sort of an issue with it whatsoever. She just wanted to keep him out.
This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth's revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped do by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. You guys didn't really think I was going to make it through this trial without him, did you? Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. it's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to G, E, and F, not the entire phone. And those materials will be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Carney's case, the search warrant affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor, Counsel.
Good morning.
Judge, this is a Lampron request, as is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties.
I'll be perfectly honest, I do want other clips that I can use, so if anyone has any ideas or if they've got timestamps or anything, I don't have a huge amount of time to go searching for them myself, but I did find that one and, you know.
Focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning there has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution as an attorney, I saw this, I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it and I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it or I'm just going to read a few things from it, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants. And
yes, Bernice, I
talk to
absolutely would
anyone
not be
she
taking
wants and
anything
communicate
away
with
on
anyone she wants. And say, hey,
face value.
don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant,
Hank's not even
and
the fallen
ultimately the
fruit.
fact that
He's
they
the
tried
worm
to use it to
sleeping
get
within
an
the fallen
indictment
fruit.
and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but
investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, "Hey, let's really get that person, and let's get them off of this, and let's try to have that person not testify. Let's scare that person. Let's harass that person." There's no communications like that. They just have the fact of communications, and that's not evidentiary. That's not relevant. So, Judge, here they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, they communicated. The fact that they communicated cannot be a basis for a criminal investigation, and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened.
Okay, so consciousness of guilt is basically, it's circumstantial evidence that is used to infer that someone understands and knows that what they're doing is wrong or improper. So it's things like fleeing after the fact or lying to cover up for yourself. It's slightly different to mens rea, which is the guilty mind, because that's when you're intentionally doing the act. Consciousness of the guilt is sort of a lesser standard. It's how can you prove that they're aware of what they were doing at the time was wrong? Whereas if they have mens rea, then it's sort of imputed that yes, they know specifically that what they were doing was wrong, and that is a given, basically. So actions to impute consciousness of guilt, as I said, are things when you go out of your way to basically either cover up or take actions against your own interests Oh, that's a bad way of putting it. Basically, when you do shit because you know you fucked up, and the court is able to infer from that that you knew what you were doing was wrong, and therefore they're able to apply that to other circumstances. That's a really roundabout way to explain that, and I may not have done a good job of that.
The search never.
But that issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant?
Right. What do they have? What do they have to set that up? They have the fact that they spoke, and the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done, where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous.
Yes,
there's
but a lot of the time, if you're drunk or you're impaired, if you've done it deliberately,
asking right now, Your Honor,
they'll apply a reckless standard instead.
The taint team to scrutinize the phones for, we're going to ask for husband-wife communications.
You're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there. We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response,
and I think the irony is that they're not going to find anything that strengthens the case in there, because they were using Signal. The messages don't exist.
I'm going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little, Your Honor.
Thank you, Your Honor. Elizabeth Little here on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look... Attorney Bradle. Apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties conflating two issues.
Professor Kasuda from Uptown, I think you'd be interested in hearing what he's got to say.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
It is true that there is litigation.
What the hell is a mens rea? It's a legal term the lawyers use. It just means the intention to commit a crime.
There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than conscience of guilt. I agreed that unless the door is open, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a conscience of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The conscience of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protecting information to Mr. Carney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on condition of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been warned. Yes, it might take...
The hell is this? See, it's interesting because here we specifically have rules about whether or not information obtained in other cases and other hearings can be used in a specific trial. Very specifically, there is a rule stating that if you obtain information or documents or whatever else as part of a civil proceeding, it cannot then be used specifically in another civil proceeding. The rules around the criminal law is a little bit different, but more or less still the same. So now what the hell is this? Why did Law and Crime all of a sudden switch to an infomercial for chairs? By the looks of it.
Thanksgiving dinner. Yes.
Guessing someone switched the channel on them. Why can't the entirety of Massachusetts speak like that, Judge? Well, you've got to keep in mind,
Your attendance, you shall be heard.
specifically not all of the judiciary in
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
As far as we're aware.
Good morning, Your Honor. Barbara Bachman for the Commonwealth.
Good morning, Mr. Walker.
I'm on for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Like that? He's got so little.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen, so I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well.
And if you'd done your freaking job, we wouldn't be worried about count 1 and 3, Bev.
Then simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5
against both parties' wishes.
Continuance. And I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury, because obviously that's when jeopardy attaches, and we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right, so let's go to the next motion, and then we'll go back to doing them somewhat in order.
So you know that there is a federal court appeal on foot that could completely torpedo your control over this case anyway, but you're going to impanel some poor bastards and keep them in limbo as well, because you're not going to be able to swear them in. She really just wants to keep control over this, doesn't she?
Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it.
I can get it.
So we did hear from people this morning. I know you all have. I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
What local merchants have requested?
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Who gives a flying rat's ass what the
Your Honor,
local
the
merchants care about?
Primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially...
Oh, you mean you're going to make sure that there's no alarms, or like there's not going to be sirens going off in the middle of the trial? Is that what you're talking about? Like those interruptions and noises? Of course not.
Impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we proposed,
like police sirens?
What I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market, in my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take up position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is, and I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Can I just have this marked for identification for this hearing? Identification.
Just very quickly, it's where... Shit, what are we... How long are we in? We are... Oh, I can't even see. Like... Shit, we've got like 2 hours in? Something like that? Where are we? 2.5 hours in. I haven't once grifted at all. People, if you are not subbed to the channel, if you're new here, if you're whatever else, maybe just think about hitting like button and seeing whether or not you're interested. For those of you that are returning viewers, make sure you head over to @Aussie Overlaw'd New and sub up there. I'm putting out my pre-recorded and fairly heavily edited videos, dipping my toe into whether or not I should have a koala VTube avatar. But I'm trying to put out a new video each week and just see whether or not that channel does any better than this one in terms of being able to retain subs and various other bits and pieces. So if you wouldn't mind, that'd be hugely appreciated. Otherwise, double check whether or not you're still subscribed here. Why did it not work? Why you no work?
And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly. We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
I do kind of feel sorry for Lally, because at this point I feel like he's doing all the work and Brennan's
So
just
the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing.
Oh, what a crock of shit.
I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from...
I don't have a problem with that. I still need cities and towns.
Of course.
Okay?
Yeah.
All right. Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
Commonwealth first, Your Honor.
Oh, it's defendant's motion. The Commonwealth opposed it.
You had asked who's arguing that for the Commonwealth. That's why
I'm sorry, defense motion. Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the...
I'm fine with him going first if you'd like.
Okay.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about the directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications. But if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before.
He's also committed, this guy's an absolute wank, but I've just realised he's also committed one of the cardinal sins in court as well. Grey pinstripe suit, white shirt, grey tie with circular polka dots. Pattern on pattern is a no-no.
Trial, in my opinion. We do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have
Get
been
rejected, yeah. As well they should.
Unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose.
To be fair, it could also imply something that you don't want put out there either, that the investigation is over and that the indictments are coming. You can say whatever you want. There's multiple ways to look at that.
And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently, and then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved.
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply. We haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just asking the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Ron. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is, Your Honor,
yeah,
they did speculate.
That's
worked. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into.
Okay, so first of all, and this is later in my argument, we're not asking.
So, no, could you answer that now, and then I'll let you say everything.
Your Honor.
Oh, you just said it's late. Hold on. You just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Oh, hang on. Yannetti grows a spine in terms of Bev. I'm rewatching that. Hang on.
Just about to say, but I'll address it now.
Okay.
It's that moment there. Right there. He is fed up and he's had enough. As well he should be.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered. Nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what.
No, look, I honestly can't say that I blame that there's been a shift in how the defense have felt about it. I mean, Yannetti specifically, after the hearing the other day when she was going in on him about how he was the attorney of record from Massachusetts and that, he could be the one to try the case moving forward and all that sort of stuff. Like, there were very clearly, very thinly veiled threats there. And the way that she just tends to condescend and belittle, which, I'm sorry, she may be sitting at that bench, but she's still just a lawyer in a robe. It's not like her shit don't stink, And it's about time that the defense started hitting back a little bit harder.
What happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA, and they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023 describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right? So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
Of course.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that we have a jury sitting for weeks at a time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was, and the court made a ruling on that objection and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth is, what's the basis for your objection?
To make a record at that point.
Well, I understand, but it's...
This is going to piss me off.
What's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know.
I agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It will allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion.
Oh, out of hand
Defendant's
as well.
motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after Dr. Russell's testimony. All right, there's a motion. It's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So.
Oh, you can keep saying that, but we know it's not true.
There's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant, and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alessi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, the jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
All right. Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
Maybe that's because they're going to actually have to use the sidebars to raise their objections.
Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly, and for that reason we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So
yeah, well, you don't have that
this
now,
time
Bev.
there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority, and I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to that, Ms. Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth v. Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses at a call regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different from questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted, and it should follow Massachusetts general laws, and it should follow Massachusetts case law. For those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for the defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined, and that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw her. Dr. Scorti Bello? Oh.
Not on their witness list.
All right.
She's number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize, I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner, so that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick motion. So that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. It does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of this office? Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, there may be people who have a criminal record and re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. And I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all, too, to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up, and I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're giving the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
Okay, so first things first, because I was in the middle of something else, so I didn't really have the ability to pause and comment on it. The whole speaking objection thing, not being able to say objection relevance, objection hearsay, objection whatever, that really frickin' pisses me off. I have no idea how, when, where, or why that was instituted in Massachusetts and why they continue to allow it. But more to the point, as far as I'm concerned, the only reason that Bev would have an issue with it is that it allows for appealable issues to be more easily identified. And I think someone mentioned it in one of the comments that Ian said it. I would fully expect the defense then in this instance to, on every objection, call for a sidebar. Because that is really the only option that they're being left with in order to make sure that the proper reasons for the objection and the ruling are properly recorded. Even if she's going on about how they're going to seal the sidebars, which frankly I think is a bit bullshit as well. But having a block on speaking objections like that, it boggles the mind to me. It's not something that I can wrap my head around, because the only reason that you would create that kind of cloud is because you're trying to hide shit. This is one of those things that sunshine is the best medicine. And I'm not sure if it's just that she's trying to make sure that she doesn't get overruled on this one, or if it's just that... I mean, the trouble is that what it does is it takes me back to a clip that I've seen from, was it The Good Wife or The Good Fight or whatever it is, and there's a judge who specifically doesn't rule on motions. And by not actually issuing a ruling, it means that she can't, her decisions can't be appealed. And like, she gets really shitty when she gets called out on it, but like, she wants as many left open as possible. Well, I'm not so sure, honestly. Yeah, exactly. Make her get it on the record. But anyway, we seem to be making good time, I think. Oh shit, it's 1 a.m. Oh, what do I do here? What do I do here? What do I do here? When's the next break? We're at 2:02. Come back at 2:25. When's the next break after that? Presumably it's going to be fairly lengthy. What's that, another hour and a half? I can't do it. I got to get up and I got to finish cleaning and stuff for the rental inspection tomorrow. So what I'm going to do, people, is as soon as I can, tomorrow I will be back trying to power through more of this, but for the moment I got to get some sleep. You know what my sleep schedule's been like with working, driving and all that sort of stuff. Last thing I need to be is cranky and that sort of thing tomorrow. Best part left is about the procedure expert. Okay. Shoot, what time am I looking at? So, I mean, they're supposed to leave any time. Apparently, the inspection's any time between 11:30 and 1 p.m. tomorrow. So, what am I looking at time zone wise? Time zone calculator would be helpful. And time zone Melbourne, and then we go Eastern. All right, I will try and start again before 10:30 p.m. Eastern, okay? Just because I've got to get some sleep. Otherwise, it's going to be a very short trip. All right. But anyway, as always, people, thank you very much for joining me and for helping me catch up on the chaos. It's going to be interesting because not only do I have another, 4 or so hours of this, I'm assuming today's going to be a banger as well. But anyway, as always, please remember you're not a piece of shit. You have value and do contribute to society, especially for being here. And yes, I'm tripping over my own words in order to get through this quickly. But as always, please stay healthy, wealthy, and wise, people. Hit that like and subscribe button, double check, and I will see you all shortly. Cheers, peeps.
And again, on your way out, please do me the favor of hit the like and subscribe button if you're so inclined. It costs nothing. It's absolutely free, and we'll be friends forever. Bye now.
this shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me, I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.
We good? We good? Oh, we didn't actually. Looks like most of you know about the aftershot thing. Well, look, it's not going to be very long, but I just for those of you that follow on the car streams, I know that it's a little bit difficult to whatever time zones and all that sort of stuff, but I am working on different ways to be able to get stuff done properly in the car. This week's just been a little bit crazy. Hopefully we'll be back to crazy Karens and body cams next week, and then after that we've got the Hughes trial that I'm going to start doing as a rewatch. So it's more just making sure that I've got all my ducks in a row, because as bad as it sounds, if one thing goes wrong of a morning, I can't stream at all. And that's maybe I've forgotten to charge the battery for the Starlink. Maybe it's something weird, some weird connections going on. Maybe it's I slept in 10 minutes too late and I don't have time before getting to work. But I'm going to make more of an effort, is what I'm saying, okay? But the afternoon streams for me, which I know were like ridiculously late US time, I do thank you very much for everyone that watches those and for keeping me company on the drive, because it means that I don't wrap myself around a tree. Depending on how we go, we'll see whether or not those transition into me just doing nighttime streams like this again. Trouble is, if I do the nighttime streams, they're going to have to be short. Like, I'm talking like an hour long, basically. And because I've just got to make sure that I'm still getting enough sleep. Fingers crossed I'll be able to be doing the Karen Reid trial, if not live, then hopefully on the same day-ish. Just got to work out, like, internet usage and that sort of thing at work. But anyway, peeps, I'll catch you all later.